Hi, this is Chuck Stell, looking at business practices that are restricted or prohibited by antitrust laws. Business practices can hurt consumers or they can hurt competitors. And harm to consumers, we've talked about to some extent already. So price fixing, of course, is something that directly harms consumers, but also quantity agreements. If every producer produces 10% less, that will have an impact of having a price increase. Agreements to divide markets. I get Michigan, you get Indiana. Again, that would give me more power here, you more power there, and there'd be less competition in both states. Agreements to limit advertising. I won't disclose the price at my stores if you don't disclose the price. Again, providing less information to the consumer gives more power to the firm. And these are all types of restraint that have been found illegal under the Sherman Act, Section 1. And again, those antitrust prohibitions were designed to protect the consumer. The Sherman Act, Section 1 provisions. But there was another legislative concern that has increased and decreased at various periods over the last century, and that is unfair business practices that target competitors. So using pricing strategies to eliminate rivals, or favoring certain customers and hurting others, or extending market power or monopoly power into other sectors. Now, in theory, our antitrust should focus on protecting competition. Sometimes it seemed to focus a little more on protecting competitors. And certainly the Brown Shoe or Vaughn's Groceries seemed, those anti-merger decisions seemed specifically to save some competitors as opposed to overall increasing the level of competition. So let me talk about some business practices that can harm competitors. Price discrimination, charging different prices to different retailers, say, can hurt a particular firm. And so price discrimination could favor some suppliers in certain locations over others. Tying, requiring the purchase of a separate product along with a different product or one product along with another, may foreclose markets to potential competitors. Exclusive dealing, if you buy from us, you cannot buy from our competitors, also forecloses competition. And then predatory pricing, charging an abnormally low price to eliminate competition, are all things that have been political concerns at different times. And we have certain laws that have been enacted in order to deal with these. And that's what I'd like to look at now. So starting with price discrimination. Price discrimination can be seen as an exploitation of monopoly power, hurting some businesses but helping favorites, or it can be seen as a type of predation, using low prices to hurt a rival in perhaps one city without lowering the price generally. So price discrimination, as we talked about earlier, is charging different prices to different business customers for the same product, and the CLAYTON Act, Section 2, prohibited price discrimination if it would substantially lessen competition. And so not all price discrimination, but price discrimination that has a competitive effect. Now, in 1936, the price discrimination was further restricted by the Robinson-Patman Act. And this was passed to help small businesses compete against the growing power of chains. This was very much a populist law, and the concern here was about competitors, not about competition or efficiency. And to some extent, the specific elements of the Robinson-Patman Act are no longer broadly enforced. Let me look at tying and exclusive dealing. And again, the CLAYTON Act has a prohibition on tying and exclusive dealing where the effect may be to substantially lessen competition or tend to create a monopoly. So again, not everything is illegal. And there are many reasons why businesses would contract with one supplier that are not anti-competitive. From the Federal Trade Commission website, these are generally lawful. The only concern is when there's a decrease in competition or when the exclusive deal is designed to extend monopoly. So franchises that we talked about earlier often can be exclusive. Pouring rights, like K College has Just Pepsi, again can be an exclusive. And um, it's thought that these kinds of contracts can promote competition between brands. And so these kinds of deals are judged under the rule of reason, and often with the presumption that they are pro-competitive or have some efficiency standards. The illegality comes when there is a dominant player and then exclusive deals. So there was a case where a tooth manufacturer with 75% of the market share required exclusivity from dental labs for dentures, and that made smaller firms unable to compete. So exclusive dealing, we see many kinds of exclusive deals. It's only certain restricted cases where it would be outlawed. Now, tying is requiring customers to purchase products together. And there have been some well-known cases here. IBM, the computer machines and punch cards were required to be purchased together. We will touch on that perhaps briefly when we talk about technology. Copiers often would have service contracts or at one time even paper tied to the purchase of a copier. And there were a variety of legal theories as to why tying would be illegal. One would be that it would foreclose competing businesses to reduce competition, and a second would be that it would leverage monopoly from one sector to another. Now, there was an economic criticism of the second one, is if you already had a monopoly in copiers, why not just charge a higher price for the copier, the tying good, and ignore the paper and just let that be treated as a market? Now, another group of economists looked at tying as an indirect form of price discrimination, so that the bigger users who need more paper and who would have a higher willingness to pay will end up paying more by buying the copier and the paper from the same company, whereas the smaller users, right, who are going to use less paper, less of the tied goods, and would be farther down, farther to the right on the demand curve, have a lower willingness to pay, end up paying less. Often business argue quality control. There has been a tying case that went to the Supreme Court. That was the International Salt case in 1947, where there was a patented machine that the company was selling, and they required salt to be purchased from the company as well. The Supreme Court at that time prohibited tying and made it per se illegal, but there has been a move through lower court decisions towards a rule of reason for tying. The final antitrust law is one that had been ignored for nearly a century, and that is Section 5 of the Federal Trade Commission Act. So this gave the Federal Trade Commission authority to enforce the Sherman Act and the CLAYTON Act, as well as other antitrust provisions, and that had been well understood. But the language is broader, prohibiting unfair methods of competition. And the Obama administration, remember this act was passed in 1914, brought standalone Section 5 cases in 2010 against U-Haul, who had made an invitation to collude with other rental companies, Avis, the Avis Budget Group, and Penske. There's no evidence that rivals accepted, so it wouldn't be a straight restraint of trade, Section 1. It's more like an attempted restraint of trade. There was no evidence that price went up or consumers were hurt. But it was seen as an unfair competition, and the case was brought under Section 5. It was settled with a cease and desist order, so the law is still being developed around the court law, the common law, is still being developed around this Section 5 of the FTC Act. Anyway, this has been Chuck Stull talking about unfair business practices from Kalamazoo College. Thank you for listening.